Now we're on the air.
Yeah.
Good evening. The Planning Policy Commission for Thursday, 25 July will come to order at 6:38. The first item of business is a approval of minutes from the April 25th meeting. Any additions or corrections?
Approve as submitted.
Second.
Second. All in favor?
Aye.
Minutes are approved. Tonight we have two items of business, two public hearings.
We do indeed.
First is Land Use Code Amendment on recreational marijuana facilities.
Yeah, there it goes.
And the second on a, hopefully, just a clarified definition of floor area, gross floor area in regards to land use code.
Yes.
Hopefully that'll be a quick one.
Hopefully.
So let's do the first. We'll listen to you, Jason, and then we'll open it for the public hearing.
All right. Good evening. I'm Jason Rogers, Associate Planner with the Development Services Department here. Tonight we're trying, I'll outline the draft amendments package for the Commission for the public. We'll get some input in the public hearing portion, and hopefully we'll get a recommendation from the Commission at the end of the night. So some background. Initiative 502 was approved by the voters in November 2012. This initiative mandated, or well, first of all, it legalized marijuana possession for adults up to 1 ounce. It also mandated that the Liquor Control Board make rules to implement the initiative and further do whatever else it needed to do administratively to implement a fully legal seed-to-sale recreational marijuana market. So the Liquor Control Board took a lot of public input. They issued some initial draft rules in May, and then they put out their official draft rules, which started the formal rulemaking process on July 3rd, 2013. So some highlights of this: they will issue, Liquor Control is looking like they're going to issue 3 types of licenses. There'll be one for producers or growers, another for processors. Those are the people who take the raw plant harvestings and turn them into whatever type of products you would actually consume or ingest, whatever else, and then retailers, which is the dispensary side of the operation. They will have application requirements to get a license. They will do background checks. They will check for Washington State residency. You need to be a resident of Washington for 3 months. They will use a disqualifying point system similar to what they use for liquor, and so they assign a certain point value to certain types of criminal convictions. So you get X number of points for, say, a DUI, say, or other points for different types of things. So if you get over a certain number of points, you're disqualified from getting a license. And then also, and this is actually mandated in the initiative itself and not really part of the rules, but they do mandate distance from certain uses, and we'll get to that one in a moment. Furthermore, there's 25% taxes at every stage here. So backing up for a second, when the producer sells it to the processors, there's a 25% tax applied. When the processor sells it to the retailer, there's another 25% tax applied. And so the taxes add up really quickly. By the initiative, the money goes into programs to help with drug abuse and things like that. The rules also mandate things like product labeling, where the plant came from, what the THC concentration is. There's a usage warning, you know, consuming marijuana may be hazardous to your health, that kind of thing. They will limit the total number of licenses issued. The formula they're using is not public, but what they have said publicly is that they make a determination. It's actually similar to how they do liquor licenses, of the number of licenses they'll issue in a certain geographic area is based on factors like population, how spread out the population is, and so for every county there will be a certain number of licenses. Some of those will be assigned to specific cities, so Issaquah could be assigned, say, 3 licenses, and then county-wide there would be a certain number of floating at-large licenses. But the number of licenses, like I said, isn't known, so we don't know how many they may or may not be looking to issue in Issaquah specifically. And finally, they have rules that the facilities need to be standalone, so it's not like you could walk into the grocery store and there'd be a marijuana section, or you couldn't walk into a liquor store and they'd also be selling marijuana. The separation requirements that I talked about earlier are pretty strict. No marijuana facility, licensed facility, can be within 1,000 feet of elementary and public schools, public playgrounds, recreation centers, public parks, public transit centers, libraries, and game arcades. However, unlike our Issaquah's current medical marijuana rules, there is no requirement to separate marijuana users from each other. So our current medical marijuana ordinance requires 1,000 feet separation between every collective garden. There's no such requirement for I-502. So you could have them locating right next door to each other. Moving on, so federal law. I know this is a big deal. Under federal law, marijuana remains a Schedule I controlled substance. It's completely illegal. It has, according to federal law, no medicinal value whatsoever. The U.S. Attorney's Office, for the Western District of Washington, and the Drug Enforcement Agency have, conducted raids on medical marijuana facilities. They most recently did it this week. There were 3 raided, one in Seattle, one in Olympia, and one in Snohomish County. They conduct raids every roughly 3 to 6 months on various dispensaries. There's not a particular pattern to who they raid, although whenever they put out a press release, they say they're not in compliance with local ordinances, they are dealing drugs, and they're laundering money. So those kinds of things. Colorado has also legalized marijuana, and they're having similar issues to Washington as far as how to implement it and how the federal government will react. But formally, there's been no comment from the U.S. Attorney General on, what exactly they're going to do. At this point, excuse me, it seems like, Washington is very close to implementation here, and so the federal government would have to react pretty quickly if they were going to stop this in its tracks. That hasn't happened yet, but that's not to say it couldn't happen. So the proposed amendments, which you have in your packet starting on page, it's exhibits A1 through A8. The proposed amendments, we'd add some definitions in chapter 18.02, which is the definition section of the IMC. We would mandate a level 2 review, which is an administrative site development permit. That requires neighbor notification to all property owners within 300 feet. It's an administrative approval, like I alluded to earlier, and so the decision would be made by the Development Services Director. There's no public hearing, there is no city council meeting about it or anything like that. This is similar to how we do medical marijuana collective gardens today. They have the same level of review. There are currently 3 permitted medical marijuana collectives and 1 more that's undergoing permit review. They just applied recently. Let's see. So retailers, the proposal is for retailers to be allowed in the urban core, the mixed use, the destination retail, intensive commercial, professional office, and the retail zones. This pretty much encompasses most of the commercially zoned areas in Issaquah. The major exception to this, as you probably or may not have noticed, would be the cultural and business district zone. So this is a map showing, and it shows it badly, and I apologize for the quality, but it shows all the buffers from daycares, from transit centers, from parks, and it shows all our commercial zones. So you'll notice that almost everything south of I-90 is buffered out. The only exceptions would be over by where the Sports Authority is and where the Meadows Shopping Center is, and a good chunk of the Rowley-owned properties. North of I-90, it's a little different. There's obviously everything over by the city shops, the Meadow Creek Office Center, the Home Depot area, and then kind of where BMC is and part of the Pickering Place Costco headquarters. As for producers and processors, because those are different types of uses, processors are certainly more industrial in nature, and producers are a little more agricultural or industrial in nature. They would be restricted to just the intensive commercial zone, so just the area by the city shops, just off of I-90. They wouldn't be allowed anywhere else. Furthermore, we wouldn't allow them as home occupations. This is something we opted to be very specific about. and clear up any ambiguity. We don't want any of these facilities in a residential area in any way, shape, or form. One departure from state law and the Liquor Control Board rules is that we would mandate that they all be indoors. Liquor Control Board rules, the proposed rules at least, would allow grow operations outdoors, provided they're surrounded by a big fence with security cameras. After analyzing the land use code and the comprehensive plan, while the comprehensive plan does encourage small-scale agriculture, it only encourages it along Tibbetts Creek and Issaquah Creek, and most of the areas suitable for that are zoned residential, and they're zoned in a way that you couldn't just restrict it to those specific areas. You would also say you allowed it in the Tibbetts Creek area. That zoning district is also present in Overdale Park. It's present on Cougar Mountain, and so suddenly you would be theoretically allowing a grow op in areas that would not be compatible with agriculture. So, in light of that, an outdoor use wouldn't be compatible pretty much anywhere else. And so we felt comfortable saying, we want this to be indoors. We don't want it in public view. And we understand that there are climate change consequences with that as far as energy usage, greenhouse gas emissions, things like that. But in this case, the city form and public safety issues seem to outweigh that. And further, medical marijuana and recreational marijuana facilities could not locate together, so you couldn't have one single facility. You would have to be a licensed retail facility, and that's what you are, or you can be a medical marijuana facility, and you can be right next to each other, but you can't be both. So next steps, like I said, we're having the public hearing tonight. We are going to take this to the Council Land and Short Committee in August for a review and recommendation. The current lean of the administration is to recommend the city enact a temporary moratorium, however, because the Liquor Control Board rules will not take effect until September 17th, and so the administration believes it would be prudent to enact a moratorium to allow the rules to take effect, and then we'll see if any changes need to be made in response to the final rules. Make sure we have make sure the council has enough time to go through the proposed rules, the proposed ordinance, and make sure that everything matches up. We've got enough public input, and only then would the council take final action. So we're projecting the council would take action on a moratorium if they act as the administration recommends in September, and we don't have a final date for adoption of proposed rules at the moment because that's to be determined as the process goes forward. And I can take questions, or you can take public comment at your discretion.
Fred?
Oh, wait a minute here. Do they have any restrictions or rules regarding signage?
Excuse me, yes they do. There's a pretty strict restriction. I want to say it's 1,200 square inches, which is quite small. The Liquor Control Board rules would override the city sign code in this case because they are much more restrictive than city sign code would be. If I find it, I'll let you know.
Any other questions? In that case, we will open it up to public comments. If you have a public comment, please come to the microphone, address yourself, address your name and your place of residence, and we'll listen to your comments.
Hi, my name is Kaori Leish, and I live in the Rowley properties. I am 21 years old now, and I've been smoking for about 6 years, and I smoke for numerous amount of reasons, including lower back pain, insomnia, anxiety, nausea, stress. It helps me sleep. It helps me eat. I had an anorexia problem about a year ago that it helped me with, along with a vomiting problem that I had for a year and a half straight. And then I also use for migraines, pain, and depression. Growing up, I was on about 15 psych pills day and night, and some of the few ones that I can think of off the top of my head were Abilify, Depakote, and lithium. And all of those pills kind of screwed my brain chemistry up, and ever since those pills, I've had problems connecting onto things. I'm a bit slower than most would be, and the one thing that I'd like to mention is that there's a heroin pandemic going on in Issaquah, and there's been 5 deaths. There's tinfoil all over the skate park. All the junkies are breaking into people's cars, into their homes. A lot of them drive with no license, no insurance, and a lot of those people were once my so-called friends. So, yeah.
Okay, thank you. Anybody else? Yes, sir.
Hello, I'm Bruce Ferguson. I live downtown Issaquah here, and I just had a couple questions regarding the presentation. There was, you mentioned the 25% tax rate that the producer pays. Then there was another 25% that the packager pays. Is that right?
Yes. Yes, you're correct.
Okay. So is there another 25% that the public pays then? Is that,
Yes,
is that
there
what's
is.
going to keep on going?
Yeah, there's that an extra 25%, so it's at the producer to processor, processor to retailer, and then retailer to public, if you will.
Interesting. So my concern is if this 25% keeps stacking up on the cost of the product, I'm concerned that the product's going to be pricing itself out of the market, and that the market where all the importers that bring it in from other parts of the country or outside of the country are going to have a more competitive product, and this could keep the taxation from coming into the city. And I'm sure your idea is to have taxes come into Issaquah to help with whatever programs. So I'm just pointing that out and wanted to make mention of it. Okay, thank you.
Okay, thank you, sir. Anybody else? Should I ask people at home to come in, or? Nobody else has any comments, and we'll close the public hearing on these rules and open it up for discussion with members of the commission. Please.
This brought up a question to me. Does Issaquah actually benefit from any of the taxes, or is there part of a sales tax, or is that all going to the state? Or?
So the taxes I mentioned are excise taxes, which would go directly to the state. Beyond that, however, the somewhat unstated intent of Initiative 502 was to, because the intent was to create a legal market for marijuana, and so the idea is that the businesses would all be fully legal, fully above board, and would be paying sales taxes and business and occupation taxes. And so there would be a tax benefit to Issaquah in theory. The only other thing I can really say is that the State Department of Revenue has previously opined that medical marijuana should be subject to taxation. Now, obviously, that doesn't happen in all cases for a variety of reasons, but you would expect that if they have that particular opinion on medical, then it would probably carry through to this market, especially because the Liquor Control Board is going to be monitoring this much more closely than anybody's monitoring the medical market.
Fred?
If medical marijuana is included, wouldn't it fall into the same category as prescription drugs, which are tax-free as far as sales tax?
So right now, the medical marijuana is established under a completely different section of state law, and those regulations have not been changed at all. That's more a question for the state legislature and the Department of Revenue than for me. Unfortunately, I can't really answer it. In general, you're correct that prescription drugs are not taxed, but beyond that, I can't really say.
Irv?
Okay, I got a question about what's in the paper here, but before I do that, I want to say anything I say tonight doesn't mean I approve of anything we're talking about tonight. As you all know, I think that when we approve marijuana as against what the United States government is saying, we are teaching our children, if you don't like the law of this country, make your own. A great lesson for our children. But anyway, I was looking at your page 2 of 13 on the paper you handed me, and you're talking about a marijuana processor and a marijuana producer. I'm not sure I understand the difference and why you have to even bother separating them.
So the 3 tiers were established by state law, by the initiative, and producers grow. So what the State Liquor Control Board is doing is they're trying to prevent big conglomerates from.
Jason, can you turn that off? For whatever reason, it's going nuts.
Yeah, sorry. Maybe that one? Okay.
There we go. Thank you.
Okay, sorry about that. So anyway, what they're trying to do is prevent a big conglomerate from coming in and controlling the entire production chain. And so Liquor Control Board will not actually issue all 3 licenses to one entity. You can hold both the producer and the processor licenses, but you then cannot hold a retail license. And if you hold a retail license, they won't let you be a producer or a processor. That's, like I said, that's designed to create a separation between the people who are growing it and making it and the people actually selling it. But 3 definitions are laid out specifically in state law, and so there's nothing Liquor Control Board or we can do to change that.
Okay.
Any other questions, comments? I've got a couple, Jason. The 25%, is that the city initiating that, or is that Liquor Control Board?
It's written in state law.
It's going to be in state law.
Yes, it is in state law.
It is state law. Okay. So that's something we don't control.
Correct.
I also noticed on page 8 of 13, in the requirements section, we talk about no marijuana facility shall be permitted within 1,000 feet, which I take it is this,
Correct.
okay? On the next page, it talks about the requirements for an application.
Yes.
And they have to have a marijuana license or be an applicant for a marijuana license, and that they have a map drawn to scale showing all uses specified in the WAC within 2,000 feet.
Yes. We want to make very careful sure that anybody who's coming in with a license and applying for a permit knows exactly where anything is, because we don't want them to come in with a map and very carefully omit this. We want them to know, hey, you've got to, while you're meeting the letter of the law, there's a school 1,100 feet away. We want them to at least be aware of that. We want to make sure we're aware of that. Because if anybody asks us a question, they say, is it really 1,000 feet away? We want to be able to look at a map and say, yes, it is. Guess what? There's a school 1,100 feet away. There's a park 1,500 feet away. So that was the intent of specifying 2,000 feet, just to make sure that we have all the information. Because if one of those is within 1,000 feet,
You're saying that you want the applicant to provide this,
yes,
so that the applicant then is going to be responsible instead of the city telling the applicant, you're saying the applicant's going to tell the city that they're within the parameters.
we want them to tell us, even though, as you can tell from this map, we're pretty well aware of where all these restricted uses are. But we want to make sure that an applicant can point to us on the map and say, this is where we're locating, and here's all the uses that we need to be away from. So it's essentially what was the term for it? Trust but verify type of idea.
Okay, I'm not sure I understand why you have to have twice the distance. If you put a 2,000-foot circle around here, the entire city of Issaquah.
Yeah, but the 2,000-foot, there is no actual 2,000-foot circle. So asking for a map that shows all uses within 1,000 feet.
Well, I understand what you're saying, but I don't understand why you're making the people do something beyond what the definition requires.
What we're doing is we're putting the onus on the applicant to demonstrate that they are, in fact, far enough away. And we would confirm that that statement. But it's an effort to avoid us having to go out and say, okay, well, is there a daycare here or not?
Okay, I guess.
I guess I have a question even about 500 and 1,000 feet. I mean, what established 500 feet for medical and 1,000 feet for recreation? And after all, is that a distance that a 6-year-old will walk? I mean, where do you get the distances?
So 1,000 feet is the distance specified in the federal drug control
Federal?
laws. So let me finish. 1,000 feet is the distance specified in the federal drug control laws. If you are essentially caught and convicted of say, drug possession within 1,000 feet of a school, for example, it's that so-called drug-free zone, which is a bit of a misnomer. It's really just double penalties. So 1,000 feet comes from federal law. 500 feet came from the city council's discussion a year and a half ago about medical marijuana. The concern, as if you recall, when we discussed medical marijuana in front of Planning Policy Commission, this commission recommended 1,000 feet from all those uses. The city council, after their discussions, opted to drop the limit from daycares and parks, I believe, to 500 feet because there was a concern that 1,000 feet was too restrictive and would essentially preclude medical marijuana facilities from locating in Issaquah, which could have exposed the city to some legal risk or could have then not allowed medical marijuana collective gardens, which are it turned into a human services issue, if you will. So that's where the numbers came from.
Fred?
I believe the council limited the distance to 500 feet because there were already existing medical marijuana facilities that were in that distance qualification.
At the time of the ordinance being approved, there were no legal medical marijuana collective gardens in Issaquah.
No?
There was one that was located in a residential zone, which the city shut down, and there was an appeal in front of the hearing examiner and everything. But they shut down. And then they later got a permit and legally located after the ordinance was adopted.
So, during the discussion, actually, I remember, I forgot if we did approve 1,000, but actually I remember questioning why not 500 feet for some of those distances. But in this case, do we even have this is already, the state law will say 1,000 feet, right? So this is not part of the discussion whether 1,000 is appropriate or not.
Right. So the way these proposed regulations are structured is to just mirror the state requirement. I will say that, we can consider doing a different separation requirement. We could even say 500 feet. Now, Liquor Control Board is not going to issue them a license, so anything less than 1,000 isn't really, we could do it, but it wouldn't be relevant. The city can consider going further than 1,000 feet, but that then exposes you to, similar to like what we were talking about with medical and restricting it too much, it exposes you to potentially more legal liability for saying, somebody could sue us and say, well, Liquor Control Board will give me a license for this location, which is 1,200 feet away from a school, and you won't give me a permit. I'm suing you because state law says I should be able to go there. And maybe that would happen, maybe it wouldn't. It's hard to say, but that's essentially the reason why we were just mirroring the state rules and not going any further.
So can you actually clarify, is there any part of the proposed language that is not mirroring, that is actually up for discussion?
So on page 8 of 13, B1, which is they would have to be entirely within an enclosed structure. As I mentioned in the presentation, Liquor Control Board will actually allow outdoor grow operations, provided they're surrounded by a big fence with security cameras and everything. We're not going that direction. We want everything to be indoors. I wouldn't say it's in conflict specifically with state law, but we are being very, very explicit that they must be the primary use, no accessory uses, no home occupations. That's strictly speaking a little further, but it's well within our zoning powers. I mean, if you want to get a strict interpretation, the fact that we're requiring an administrative site development permit is over and above what state law allows for. But I wrote it in the introduction to this back on the first page of the exhibit. The Liquor Control Board isn't going to even really look at city zoning laws. They don't enforce city zoning. It's beyond their purview, and so they're going to rely on cities to do that. So these regulations you see are essentially an extension of the city zoning ordinance. Liquor Control will look at their rules and the state law and not worry about what we're doing. So there's some room for us to do things.
Fred, asked to your question earlier, there is provision under on page 9 of 13, talks about signage, and that all the signs will comply with the requirements in the WAC and Central Issaquah Development and Design Standards.
Yeah.
So the existing sign laws
been
would
there.
apply. Yes.
A couple questions for you. I want to be really cautious, and when we make presentations, that we don't refer to them as dispensaries, since that's kind of been done away with, unless that's in the state law.
No, no, it's not, and it's a colloquial term that I'm using in a general sense. The specific terms are marijuana producer, marijuana processor, and marijuana retailer.
It's just a recommendation to stay away from that word. On the environmental side and some of the byproducts of some of these producers and businesses that are going to be established, do we have anything that protects the surrounding areas?
As far as, dumping waste or not specifically related to marijuana, we would have any of the same rules, restrictions that are currently on the books. We have the critical aquifer protection rules for one example. You can't discharge stormwater directly into creeks without treatment, things like that. But nothing specific to marijuana, no.
Okay. And then you mentioned, some different permits here. Would there be a different cost for these permits than a standard small business would pay?
No.
That's one thing that I would recommend would probably be increased, is the cost of the permits.
Okay. We currently, for medical, we term that, so we have a couple different levels, if you will. We have a level 2 minor and a level 2 major, and we charge the level 2 major.
I remember that,
fee.
because I recommended.
Yeah, and so we carried through on that, and that would be our intent here, is they would be level 2 major administrative site development permits. I don't remember what the cost is off the top of my head, but it's a couple $1,000s.
Okay, thanks.
Any other questions? I'm sorry, the public comment period's closed. If you have a question that you want to ask afterwards, you're fine, but for comment, we're closed. Any other discussion? Okay, the chair will entertain a motion then to accept and approve the land use code amendments on recreational marijuana facilities.
So moved.
Second, there's a second? Second. All in favor?
Aye.
Opposed? One opposed, motion passes.
All right.
Next item of business is the definition of floor area gross.
So I will preface this, and you should all up there have, I include the map, and then there's another piece of paper. It's double-sided. We are adding one more housekeeping amendment tonight, but we'll get to that one in a second. So the first one, which you do have in your packet, Exhibit B1A, is clarifying the definition of floor area gross, and this is in the Central Issaquah Plan Development Standards, Chapter 2. Turns out there is some confusion over this definition because we have been getting applicants asking us, well, does gross floor area include parking structures or not? And as you can see from the underlines and the strike-throughs, surface parking was excluded from the floor area ratio and structured parking was included. But that's somewhat contradictory and not really in line with the Central Issaquah plan attempting to get, actual, we don't want to be building parking garages for the sake of building parking garages. We want development to come with it. So we would propose to clarify the definition by making it clear that parking is not part of the floor area ratio calculation, or it's not included in gross floor area rather. And then the second one, which is the one we're adding tonight, and it's Exhibit B1B. It starts at the bottom of page 1 and is on page 2. There's been a recent change in the International Building Code, and the most recent version of the IBC was adopted on July 1st by the city. And the clarification is that a building permit is required for fences that are 7 feet in height or greater. Currently, the previous restriction was 6 feet, so we would just make the minor change there. It's B5 to say that a building permit is required for any fence over 7 feet in height. We wouldn't change any of the restrictions, though, for fence height in different zones, and so even though you wouldn't need a building permit for the fence particularly, you still couldn't build more than a 6-foot fence in a residential zone without getting an administrative adjustment of standards, which is a fairly high-level planning permit. So 6 feet is about, here on me. 7 feet would be up here.
Any questions by members of the commission? We'll then open this up for public hearing on the definition of floor area and apparently also accessory structures, fences, arbors, pergolas, and trellises. Anybody from the public want to make comment? This is your chance. So 6-foot fence to 7-foot fence. I'm sorry? Come on up. Again, identify yourself with your name and address, please.
My name is Kaori Leish, and Wildwood Apartments. One of my questions was, first off, that square footage referred to like the off-limit zones versus what's allowed? Like that, this?
Oh, you're talking about marijuana?
Is this a different subject?
Yeah, this is a
Okay.
different subject.
Entirely different subject.
I got really confused.
Find me after the
Okay.
meeting, I'll definitely clarify it, though.
Different subject. Okay. Anybody else, questions on this? In that case, we'll close the public hearing on trellises and fence heights. Any discussion from members of the commission?
Come on, this is a really thrilling subject.
Okay, anybody from the public out watching TV, you're welcome to come down. Okay, you didn't make it in time.
Should I add in how many hours of staff time went into crafting this?
Yeah, lots of hours of staff. You should complain to the city council for accepting the international building standards and change it. That's the problem. All right, the chair will therefore entertain a motion on the approval of the amendment to the land use code on regards to gross floor area as well as accessory structures and fence heights.
So moved.
Been moved and seconded. All in favor?
Aye.
Opposed? None? It's passed. And that's the end of the business, unless you have anything else for us, Jason.
I do have a small other thing for the
Okay.
end. Trish and I, were recently informed that board and commission consolidation has been tabled for the time being, and so that will not be occurring in the immediate future. The administration will check in with the Council Services and Safety Committee later this fall to see if they wish to revisit it. But for now, I would say the Planning Policy Commission is in existence and will continue to exist for the foreseeable future. What this means for anybody's appointments, I don't know. We'll likely determine that early next year.
I think the last meeting we were at, we all determined that we were all reappointed for another year with doubled salaries.
We'll triple it, actually.
You're tripling it? Excellent. Thank you. Anything else?
That's all I have.
Okay, in that case, we'll close tonight at 7:18. Excellent. Thank you very much. I have to sign stuff.